The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law. And today we're going to talk about the responsibilities of a guardian in Illinois. We're going to talk both about guardians of a minor child and also guardians of a disabled adult. So first let's talk about guardians of a minor child. So in general, a guardian of a minor has the same responsibilities towards that child that the parents would have had if they were in charge of the child. So that includes being responsible for the child's physical and mental well-being, suitable housing or living arrangements, ensuring that the child receives a proper education, and ensuring that the child has access to necessary health care treatment. So you think of it as basically a substitute for the parent. It differs a little bit from the parents when it comes to receiving money. So the guardian will receive money that's due to the minor for care and support, and any money that is the minor's, either through inheritance or some other government benefit, has to be kept separate from the guardian's own assets. The guardian has a fiduciary duty to use that money for the benefit and ongoing care of the child, or if it's not necessary for the immediate care of the child, to invest it for the child's future benefit. The guardian has to keep detailed records and should keep a separate account. Like I said, no commingling with their own assets. And they may have court reporting responsibilities, typically annually, for any money that they're dealing with on behalf of the child. Let's talk about now guardians for a disabled adult. Unlike a guardian of a minor child, which is going to have broad responsibilities for all of the care, both personally and financially, of the child, a guardian of a disabled adult is typically only granted the powers necessary to do what the disabled adult lacks the capacity to do. So we have a video and article about limited guardianship. It's not terribly common, but limited guardianship is when the court order specifies only certain decisions that are going to be made by the guardian on behalf of the disabled adult, certain specific types of decisions, and the disabled adult retains all the power to do everything else and make their own decisions in other areas. More common is splitting guardianship between guardianship of the person and guardianship of the estate. And we're going to explain what each of these are and what the responsibilities associated with each are. But guardianship of the person and guardianship of the estate can be managed by two separate people, or it can be managed by the same person. A guardian of the person is the person responsible for basically non-financial aspects of the disabled adult's care. They're in charge of living arrangements, medical and personal care, arranging for those things for the disabled adult, making sure that the disabled adult is provided with meals, transportation, opportunities for socialization, and recreation. So everything that's not financial, investment, legal aspects, the guardian of the person does. And so when it's not a limited guardianship, it's called a plenary guardianship, meaning that they have responsibilities for all of these things, and they're just named guardian of the person, and it's assumed that they're going to do all of these things if it's not carved out specifically in the order. The only caveat here is that with respect to living arrangements, typically the guardian of the person can't just decide to change the living arrangements of the disabled adult. They make a recommendation to the court and get court approval of any living arrangement changes. And if the disabled adult is in a care facility, the guardian of the person is responsible for making sure that they're receiving proper care in that facility. So a guardian of the estate, on the flip side of that coin, is responsible for making financial and legal decisions, so maintaining lawsuits, making investments, paying bills for the disabled adult. The first step in being a guardian of the estate is usually identifying the assets, the different types of assets that the disabled adult has, and the different types of income they receive, whether from government benefits or otherwise. Then the guardian of the estate will manage those assets for the benefit of the ward. Again, just like a guardian of a minor child, the guardian of the estate has the fiduciary duty to act in the best interest of the disabled adult, not in their own financial interests, and they're prevented from commingling the assets with their own. So there should be, again, a separate guardianship account opened up for the estate. Like a guardian of a minor child managing finances, a guardian of the estate is going to file an annual report with the court that details any income, expenses, assets, and liabilities for the management of the estate. So if you have any questions, I know that was a lot we covered in this episode, feel free to leave the questions in the comment section below this post at learn-about-law.com or below our video on our YouTube station. If you found this helpful, please subscribe to us on YouTube, iTunes, and SoundCloud. We publish new content daily, so you'll get notified of what we're publishing and see if it's interesting to you. If you need some help, give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations, and we have offices all around Chicagoland for your convenience. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.